I think it's a much more sustainable strategy not to just put your finger up in the air and see which way the political wind is blowing, but rather to ground your strategy in your organizational values, to really go back to basics and say, well, what do we believe in as a company? Do we believe in, fairness, equal opportunity?
Welcome to the Leader's Edge podcast. I'm Zach Ewell, market analyst and podcast producer at Leader's Edge. In this episode, our editor-in-chief, Sandy Laycox, sits down with David Glasgow, executive director of NYU's Meltzer Center for Diversity, Inclusion, and Belonging, and co-author of How Equality Wins, a New Vision for an Inclusive America. In this podcast interview, Glasgow shares the current state of DEI in America and around the world, offers insights for organizations looking to explore DEI opportunities, and much more. Give this podcast a listen.
So we're going to talk about diversity, equity, and inclusion, sort of the large landscape that we're currently dealing with in the business environment. We're going to focus specifically around the legal cases that are going on, as I know that you're thoroughly ensconced in those, and maybe then you can kind of give us some advice for our insurance industry leaders who are trying to navigate.
So I think it's helpful just to define what we mean by this at the outset, which is that DEI is quite an abstract term, but each of those letters is doing work in the acronym. So the D for diversity are programs that are aimed at improving the demographic representation of a particular organization. The E for equity is about systemic work to promote fairness within, whether it's hiring or performance or promotion. The I for inclusion is about creating a welcoming and inclusive culture and ensuring that you have an environment where people feel that they belong. And the reason why I want to break that down is that from a legal standpoint, not all of those activities are legally risky in any way, right? So for example, the least risky type of work is that I work around creating an inclusive work environment. Mm-hmm. Like nobody is getting sued or targeted for efforts that are aimed at promoting a welcoming culture for everybody. And in fact, if you don't do that, if you don't care about the culture of your organization and you allow it to become toxic and hostile in how people are treated, then you are creating more legal risk for yourself rather than less legal risk. That's important as a level setting. Mm-hmm. In terms of what we are seeing is that there have been now well over 100 lawsuits that have been filed over the past few years attacking DEI-related programs, and in particular, there's two kinds of programs that seem to be targeted the most. One are what we call targeted programs, which are scholarships, grants, internships, mentorship programs, fellowship programs, and the like, that are exclusively reserved for members of particular demographic groups, usually racial, ethnic, or gender-based groups. So if you had a fellowship program where you have to be a person of color to participate, or if you had a women's leadership initiative fellowship program, you have to be a woman to access that program. Those are the kinds of programs that are getting targeted the most in the litigation. The second highest category of lawsuits are reverse discrimination claims, so claims brought by white individuals or by men or other members of dominant groups saying that they were discriminated against in their employment and that their employer's DEI program is the reason why they were discriminated against. They're saying that the employer has been favoring people of color or women in the hiring process or the promotion process, and that has caused the plaintiff to miss out on that opportunity. And so those are the biggest two categories. Okay. Most other kinds of DEI programs remain perfectly legally safe.
Is this a trend that you've seen change in the past few years, or has this always been something that you've seen?
So it really all started after the Supreme Court issued its decision in the 2023 case of Students for Fair Admissions versus Harvard. This is the case in which the court effectively ended race-conscious admissions in higher education. So prior to that time, there was always some legal risk attached to certain forms of DEI because laws like Title VII of the Civil Rights Act, which is the employment discrimination statute, or another law like Section 1981, which prohibits race discrimination in contracting, those laws have existed for decades. So there have always been some risk, but there was very little attention to DEI programs as risky per se, meaning there were very few organizations out there actively suing companies for their DEI programs. And so the perceived risk was a lot lower prior to 2023. Mm-hmm. After 2023, when the Supreme Court effectively said in admissions that you have to act in this quote unquote colorblind way, discriminating against majority groups is just as bad as discriminating against minority groups, that inspired or catalyzed all sorts of litigation challenging diversity programs within the workplace as well. Mm-hmm. And what we've seen since that time is a kind of steady progression of anti-DEI lawsuits from then until now. So sometimes people will say to me, oh, this all really hit a spike when the current administration came into office in January of 2025. That's not what we're seeing in the legal environment. As far as lawsuits go, it has just been a steady hum or a steady progression ever since that June 2023 decision, with no obvious spike at all with the current administration coming in. What has really happened with the current administration is that it has poured fuel on an already raging fire. Within the first couple of days of the current administration, the president released a series of executive orders cracking down on DEI, and the most relevant one for private sector organizations was one about so-called illegal DEI. And what that executive order essentially said was that federal contractors or federal grant recipients were now going to be required to certify as a condition of the contract or grant funding that they do not promote any programs that are unlawful forms of DEI, right? And so we use this terminology of unlawful DEI or illegal DEI, which created a lot of confusion because it didn't identify what exactly was unlawful DEI. So it sent particularly federal contractors into a bit of a tailspin of like, how do we assess whether or not our programs are unlawful? And how do we tick this certification? Because if we tick the certification and then the federal government investigates us and concludes that actually we are doing illegal activity, then that's going to really hurt us. Like we could lose our federal contracts or our funding, and we could be sued under another statute called the False Claims Act for falsely certifying that we don't do anything unlawful when we are doing something unlawful. So that was the main impact of the administration. But then what we've also seen the administration do is appoint anti-DEI leaders to key federal agencies like the Equal Employment Opportunity Commission and the Department of Justice. And those agencies are actively investigating companies for engaging in what they consider to be unlawful forms of DEI, even if they're not federal contractors. So the EEOC might crack down on a company for having a program that excludes certain groups from participating in the program, for instance. So it's the executive orders, and then layered on top of the executive orders are these actions by federal agencies. One of the things we've seen from this administration is they want to have a wider impact than just the lawsuit itself, right? A lot of what they've been doing over the past year has not actually been litigation. A lot of what they've been doing is what I would consider to be more of like a PR exercise. Mm-hmm. They've been writing letters, they've been sending tweets, they've been saying things on podcasts, they've been, and so I think what they're engaged in is a public relations campaign to attack DEI and make everyone scared of doing DEI work. And so when they get into a courtroom, I think you're right to observe that they seem to be saying, well, let's go after some high profile companies so that this gets written up in the media and we can draw more attention to it, as opposed to your point, like some organization no one's heard about or cares about.
Yeah. So for the cases that you all are paying attention to in your work, are there any in particular that you're watching that you feel will have really important consequences one way or another? Mm-hmm.
One that I'm watching closely is a lawsuit that the Department of Justice brought against the state of Minnesota for challenging its affirmative action program for its civil service employment. And the reason I'm watching that closely is that the Department of Justice is specifically taking aim at two old Supreme Court precedents that said that you are allowed to engage in workplace affirmative action. So one of the quirks of the legal system, of the legal landscape right now, is that affirmative action in higher education is unlawful after this Harvard decision. Mm-hmm. But affirmative action in the workplace is still technically lawful because of these old Supreme Court precedents. So there's this kind of strange disconnect in the legal landscape. Well, this lawsuit against the state of Minnesota is directly attacking those Supreme Court precedents and effectively asking the courts to overrule those precedents. And they filed the case using a provision of Title VII that allows them to go straight to a 3-judge panel with a direct appeal to the Supreme Court. So what they seem to be doing is trying to tee up a challenge that will go up to the Supreme Court so that they can formally overrule those precedents and have the Supreme Court definitively declare that it is now illegal to engage in workplace affirmative action. So that's taking it a few steps further than what it is right now, but it's one that I think is worth paying attention to closely.
Let's talk about sort of the ways that employers who are still wanting to create an organization that is diverse and equitable and inclusive, what are the ways that they can continue to do this, that if they don't have a high risk tolerance or depending upon their level of risk tolerance?
So I would suggest that you apply a filter that we call the 3 Ps. So our center developed this framework to help you decide whether or not a program is legally risky. And it has to hit all 3 of these Ps. The first is that it confers a preference, meaning it treats some groups differently from other groups. The second is that the preference is on the basis of a protected group status, meaning under Title VII, the protected groups are race, sex, color, national origin, religion, sexual orientation, gender identity. So if it's a preference for one of those groups, that's the second P. The third is that it relates to a palpable benefit, meaning there is a real benefit that people are getting from that preference, or there is some harm that someone is experiencing from missing out on that preference. If you hit all 3 of those Ps, it's legally risky. If you are missing even one of those Ps, it's safe. Okay. So, just to give an example, if you had a group-specific internship or fellowship program, if you say you have to be a woman or you have to be a person of color in order to access this internship program, that would hit all 3 of those Ps and be a legally risky program. Whereas, let's say you have a program that anyone can apply to, but is thematized around issues of racial equity or gender inclusion, that would be fine because it's not excluding anybody. Or let's say you're engaging in recruitment and you have a quota system where you say we have to hit this threshold number of people from underrepresented groups. Well, that would be legally risky under the 3 Ps model. Whereas if you used a structured recruitment process where you said, let's remove implicit bias from our systems by creating job relevant criteria, ensuring candidates are assessed fairly against those criteria using a scoring rubric, that's not giving a preference to anyone over anyone else, and so that would be legally safe. So I think if leaders apply this 3 Ps model and sort all of their programs through that filter, they will be able to determine which programs they need to tweak and which programs they can safely continue. The organizations that have the most trouble are smaller organizations that don't have a big legal team or have lawyers who specialize in employment or anti-discrimination law. So obviously if you're a big Fortune 500 company and you have a huge legal team and you have people who specialize in this area, you're fine at doing that kind of analysis. If you are smaller, you might struggle a little bit, and that's where I would recommend people check out a resource that we have publicly available called the Advancing DEI Initiative, which is a website, advancingdei.meltzercenter.org, where we track all the litigation, and we have a resources page for organizations like those. The bit that even sophisticated organizations are struggling with is not the legal side, it's more of the political side, which is, I have leaders say to me, we are confident that if we get sued and we have to defend our programs in court, that we will be able to win that court case and prove that our programs are legally safe. What we are not confident on is how do we avoid getting targeted or threatened by the current administration? What if we get slapped with an executive order targeting our company? What if we get stripped of our government contracts because someone in the administration finds that on our website somewhere we talk about DEI and they don't like that, and so they, cancel our contracts, or, there's some other kind of targeted threat or punishment that gets meted out to our company. That is where a lot of organizations are still struggling how to navigate that. And that's where I think lawyers are not necessarily best place to be able to give guidance, because then you're moving out of the realm of law and into the realm of political science.
For global employers specifically, this is an interesting concept because this is not the same everywhere.
So a lot of countries are moving full steam ahead with diversity and inclusion, even as the United States is retreating. So for example, the EU has major new laws in place around gender pay equity and around the advancement of women on corporate boards. Or, you mentioned that I'm from Australia. They passed a law just a couple of years ago that requires organizations over a certain size to adopt 3 gender equality goals, at least one of which has to be numeric. So it could be, for example, a representation target for women, something that would also be considered potentially legally risky in the United States, depending on how it's designed. But it's not just, the EU and Australia. Canada, the UK, Japan, Brazil, India, many countries around the world are moving in a pro-DEI direction. So that creates a few challenges. One is from a pure business standpoint. So there was a report in the Telegraph in the UK about a contract with Transport for London, which is the public transport agency in London, where Accenture put in a bid for that contract, but the contract was denied because Accenture had pulled back from DEI. And Transport for London had a policy where they wanted to ensure that all of their suppliers were committed to diversity and inclusion. And so they announced, actually, in denying the bid to Accenture, that Accenture didn't meet their standards for the contract. So that's one set of risks, right? You might, if you pull back, you could get lose business in these areas. Another risk is a bit more amorphous, but it's more around the kind of culture and brand identity you want to have as an organization. So I've spoken with leaders who say, we are proud to be known internationally as an inclusive brand, right? We sponsor Pride. We are known to be like a best place to work for women. And, we've cultivated that kind of brand identity over a period of decades. Many people come to work for us because they say, we think of you as a progressive organization. And so what they're concerned about is not necessarily, I'm going to lose a contract somewhere. They're concerned about, if we pull back too much from this work, it's going to damage how we're perceived in the market, and it might damage our talent strategy, or it might make it harder for us to have a cohesive identity across borders, where we don't want people, if we have people moving around a lot, sometimes we have workers who had to do a stint abroad or, work on cross-national teams. We don't want some weird cultural disconnect where the US portion of the business is this outlier and everywhere else in the business is a different way. And so figuring out how to align that strategy is another challenge. And, my center wrote a report a few years ago about global LGBTQ inclusion, which is where this really comes into play a lot, because you will have companies that have operations in countries where it's actually illegal to be gay, right? And so how do you, offer, say, spousal benefits to people, in some country where it's illegal? And so that has already been a challenge in other areas up until this point. It's become a broader challenge now across the whole DEI spectrum, and not just in that setting.
All right, last question for you. You talk about taking the long view on this. Can you talk to us just about that and what that means?
Yeah, so I'm concerned about the fact that there has, over the past few years, been this strange game of ping pong or pendulum swing, where in 2020 there was tremendous pressure to do DEI work, so a lot of organizations jumped on the bandwagon, and now 6 years later, there's all this pressure to retreat from DEI work, so organizations are moving full steam in the other direction. I think it's a much more sustainable strategy not to just put your finger up in the air and see which way the political wind is blowing and figure out like what to do, but rather to ground your strategy in your organizational values, to really go back to basics and say, well, what do we believe in as a company? Do we believe in, fairness, equal opportunity? Do we want to cultivate the kind of culture in which everyone feels welcome and everyone feels a sense of belonging? If we do have that as our organizational part of our organizational vision and mission, then that answers the question that we should be committed to this work. And it's just a matter of finding what are the strategic, responsible, legal ways of doing it in whatever environment we happen to be in. And in particular, I think it's helpful for organizations to also remember that the youngest generations are the most supportive of the work of DEI. This shows up in survey after survey, poll after poll. So if you're thinking about the long term of who is coming into our company, who are we trying to recruit, and what are the kinds of values that those recruits are going to take through with them as they enter the senior leadership ranks of our organization, I think it would be kind of short-termism to abandon, DEI when the people who are going to be taking over your organizations are the most supportive of these values.
That was Sandy Laycox, Editor-in-Chief of Leader's Edge, interviewing author and professor David Glasgow. I hope you enjoyed it. For more episodes of our Leader's Edge podcast, subscribe or go to leadersedge.com.